279, any worker whose employment has been terminated as a consequence of an unlawful lockout shall be entitled to reinstatement with full back wages. For that matter, one can assume that even where the lockout is legal, the lockout employees are entitled to reinstatement after the case is settled or as a result of an assumption or certification order, which amounts to a return to work order. But payment of full back wages is quite another issue, where the lockout does not suffer from illegality. In such case, the employer declared the lockout within the bounds of law. He has the right under the law to deprive his employees of work during the lockout. So, there is reason to believe that the no work, no pay principle applies. The rules on legality of a strike, as far as pertinent, also apply to a lockout, especially with respect to the grounds therefore and compliance with the procedural requirements existing injunction or agreement, no lockout clause. The same article provides that mere participation of a worker in a lawful strike shall not constitute sufficient ground for termination of his employment, even if a replacement had been hired by the employer during such lawful strike. On the other hand, any union officer who knowingly participates in the commission of illegal acts during the strike may be declared to have lost his employment status. Whether a strike is legal or illegal, a mere member of the striking union may be declared to have lost his employment status if he committed illegal acts during the strike. But a union officer may be so declared for merely participating knowingly in an illegal strike, and also where he committed illegal acts during the strike, even if it was a legal strike. For this purpose, shop stewards are considered as union officers. Shop stewards are union officials who represent the union members in a certain department. They also deserve dismissal for knowingly joining an illegal strike. The evident reason for such difference in treatment is the fact that union officers, by accepting union office, assume greater responsibility than mere union members in complying with the law. In the case of Isalama Machine Works Corporation, NLRC, the Supreme Court held that the union president and leader of the ill-considered and strike had a greater liability than the mere members because he had the responsibility to ensure that his followers respected the law. His dismissal therefore was warranted. Union officers are duty-bound to guide their members to respect the law. If instead of doing so, the officers urge the members to violate the law and defy the duly constituted authorities, their dismissal from the service is a just penalty for their unlawful acts. The officer's responsibility is greater than that of the members, but in the case of an ordinary striking employee, he cannot be terminated for mere participation in an illegal strike. There must be proof that he committed illegal acts during the strike, and the strike who participated in the commission of illegal acts must be identified. The penalty of dismissal for merely participating in an illegal strike is limited to leaders. Mere participation in a lawful strike is not sufficient ground for dismissal of a mere union member. This is true in spite of the fact that a replacement had been hired by the employer. This means that the employer struck against is not barred from hiring replacements for the strikers, but the tenure of the replacements is subject to the right to reinstatement after the strike of the employees that they replace. Replacements for non-returning strikers have acquired a right to their employment, but the employer is prohibited from employing, in place of the strikers, may any government official or employee, or any member of the armed forces or the police, or any armed person. For a union member to suffer the consequences of loss of employment, he must have knowingly participated in the commission of illegal acts during the strike, such as assault, infliction of physical injuries, and etc. Failing to heed the order of an office superior not to join the picket line is not such an illegal act. Mere membership in a union does not ipso facto mean participation in a strike. Such participation and intransigence to a return to work order must be duly proved to justify immediate dismissal in a national interest case. As a rule, the liability for illegal acts committed during a strike is individually. It attaches to the person who committed the same. This is a departure from the rule of vicarious liability discarded with the taking into effect or the Industrial Peace Act, where mere membership in a union served as basis of liability for acts of individuals done on behalf of the union, a case of guilt by association. However, the liability becomes collective if the use of force during the strike was widespread and pervasive, consistently and deliberately resorted to as a matter of union policy, or the union, through its leader, authorized or ratified such acts after actual knowledge thereof.